What if I told you that every law that binds you also contains the remedy to free you, but they've trained you to not look for it? Now, in this video, I'm going to reveal how remedy is always hidden in plain sight. I'm going to talk about how statutes are designed with escape hatches and how to spot your legal leverage most people never see. Now, I've studied consumer law, contract law, and administrative remedy, and I'm here to help you stop playing defense and start asserting your rights. Now, before we dive into this video, okay, this is not legal advice. This is not financial advice. Everything that I talk about today is just for educational purposes only, so that you can be empowered to take action, okay? My job today is to help you overcome the fear of asserting your rights, okay? Help you understand the law so that you can actually start taking action towards your goals. Everything that I talk about is to help you get outside of the box and question, those negative authorities, okay? Look, I want to stop paying debt, or why do I have to pay debt? Well, the conversation or debt is spiritual warfare, and I talk about this in all of my videos. So enough of that. If you're brand new, hit the like button. When you hit the like button, this helps the algorithm, okay? Thank you guys for doing that. Now let's go ahead and dive in, all right? Because we got a lot to get into today. So I hope you have your notebook out and your notepad, and you're going to take notes throughout this video, okay? So let's go ahead and dive in. Every law has a built-in remedy, okay? Statutes are one-sided. They offer remedy to avoid being unconstitutional, okay? So when you think about the aspect of something being unconstitutional, it's something that goes against the Constitution, but the Constitution is put in place to uphold your rights, okay? Remedy is always present to maintain equity, but it's never advertised. When we think about equity, it's just, the origin of equity is very similar to equal, okay? Or when you think of equity, it has a value to it, okay? You guys can cross-check me for that. Now, agencies, courts, and creditors benefit when you don't invoke your rights, when you don't invoke the remedies that you have available to you. And this is why we talk about everything that we talk about in this video, on this channel, about consumer laws, about debt discharge, about credit, about financial processes, contract law. Okay, because I want you to understand that if there's a way in, there's a way out. Dig me? If there's a way that they can control you, there's a way for you to get out of their control and take your control back. A lot of times we think that they are the authorities and they make the rules, but you make the rules. Dig me? Now, because if there was no remedy, the law would be slavery, and they know it. Now, slavery goes against common law, okay? Common law is the law of the land. Common law is the supreme law of God, okay? Whether you believe in God, whether you are religious, or whatever the case may be, just know that there is a higher power beyond the government. You dig me? And then there's a higher power beyond that higher power above the government. And just know that that higher power wants things to be in order, okay? The only way that they're able to overcome some of these inalienable rights that we have is when we contract to it. And that's why it's so key to understand contract law, okay, and comprehend contract law. All right. Now, here's where the remedy hides. You'll often find remedy in the exceptions, not the headlines. Okay, so at the top of the statute, at the top of, your contract or whatever the case may be, you won't see the exception. You won't see that you have the right to cancel. You won't see the fine print that says that you can opt out a company reporting on your credit report within 30 days, or you can sign to opt out. Okay, you'll see it'll end up being in the footnotes, the subsections, or the cross references. It'll be buried in code like UCC 1-308 or 15 USC 1692G. You'll just see Fair Debt Collection Practices Act. Or as a matter of fact, there's so many sections that, we'll just go based off the state statutes where, it'll be very surface level. But when you dive into some of these laws and you look for yourself, you'll see that a lot of the information is already kind of there. Okay, or even when we talk about the coupon method, a lot of people don't know that you can go to 328 endorsements for, requirements for endorsements, and you will see that it tells you right there how to put together a coupon. You know what I mean? So in 31 CFR 328.6, okay? Now, here's some common remedy examples, okay? The fact that you have a right to dispute any and everything, okay? Whether it's debt, whether it's information, and that's very surface level. You can dispute anything. What is disputing? Disputing is, questioning the validity of something, okay? You can disagree, okay? You can argue, you can debate about something. You have a right to argue, long story short. Then we talk about you having a right to request proof. So when it comes to them saying you agreed to pay something, you have a right to request proof from the debt collector to prove the validity of the debt. You have the right for them to prove that they are the legal holder in due course. You have a right to ask them for proof that they didn't already make money off of your promissory note. You can ask them for these things, and if they ever come back and say that what you did was fraud, that will be defamation of character. That will be them literally not trying to adhere to your right, and your right is more powerful than whatever they're going to try to say to manipulate you. That manipulation is them violating your rights. Okay? You have a right to rescind. What is rescinding? Let's pull up the definition right now, just so you guys can see. You know what I mean? Rescind, revoke, cancel, or repeal a law, order, or agreement. So you have a right to rescind an agreement, a contract, whatever the case may be, that you deem is not valid. Okay? Then we have right to cure. You have a right to cure your wrongdoings. If you did something wrong, you have a right to cure whatever you did wrong. If you harm somebody, you can cure it. And usually they should give you an opportunity to cure. That's why when I teach, okay, yes, I can teach the aspect of challenging the company, but in the administrative process, I tell you, okay, give them an opportunity to cure, because you giving them an opportunity to cure is you moving in good faith. You are allowing them to move on a right that you have yourself, and inherently they should treat you the same exact way, okay? But they'll usually bold the threats and they'll bury the exits, okay? They won't tell you how any of these rights. They won't tell you that you have the rights of this, but they'll tell you exactly what will happen if you don't do X, Y, and Z. This is why it's important for you to get well versed on these laws so that you know what your right is, okay? Some of us get scared when it comes to debt validation, a simple process like debt validation, and we think that, we are committing a crime by asking a company to prove whether or not the debt is valid. But when you look at 15 U.S.C. 1692G, it says that you can challenge a company based off of that, okay? But here's why they don't teach you this. The system profits when you are reactive and not informed. I talked about this in my last video where I said that fear fuels profit, okay? So when you're not informed, you'll just react. If they say we're going to garnish your wages if you don't pay this $1,000, 1,200 back by in the next 10 days, you're just going to react based off of what they say. But you have a right to question what they say and see if they're within legal standing to even do that, okay? But you won't know to do that if you're not informed. Some of us think that we just need templates and this, that, and the third, and boom. But if you don't know what the templates are inherently doing, you're going to when they say what you're doing is fraud, you're not going to challenge them on it. When you submit a coupon, they say, oh, well, you can't do this. You have to pay with $1. You don't even know what the definition of tender is, which is an unconditional promise or offer of money. So if they say, hey, you need to give legal tender, this is legal tender. You dig me? Yes, 31 USC 5111, I believe. Let me pull that up. 31 USC 5111. I could be wrong. Okay, not that one. I'll pull it up in a second. Oh, 5103, okay, defines what legal tender is, okay, and you can look at 31 USC 5111, United States coin or currencies, including Federal Reserve notes and circulating notes of Federal Reserve banks are legal tender for all debts, public charges, taxes, and dues, but it does not say that this is the only legal tender. It just says that this is legal tender. So they'll probably pull up this law and say, well, this is legal tender, or you have to use legal tender. You'll look at this law and think that this is the only thing, but this is the fine print. This is what they're putting in bold, but the fine print, or what you don't see, is what it is also, or what it is not, which is not the only thing that you can use to pay for debts, public charges, taxes, or dues. It does say that foreign gold and silver coins are not legal tender for public and private debts, but if you're not giving that, then if I told you that the Federal Reserve notes or the dollar is also a promise to pay, and I told you you can create your own, this is stuff that they don't put in the law, okay? So when we go back to why they also don't teach you this, is because the schools want you to be obedient to the law and not really navigate it. They don't teach you the navigation of it. They teach you to just be obedient of it. Whatever they say, you must do. But there's nothing they're teaching you about how to be able to challenge the law as well. You have a right to challenge man-made laws, okay? And some people will say, okay, well, you know, how come the attorneys don't talk about this? Well, the attorneys often focus on litigation, which is a process, versus remedy, okay? They don't care about someone really asserting their rights, in a sense. They only care about the money that they make, okay? If the litigation goes longer or whatever the case may be, they make more money from that, okay? They only care more about the procedures than actually getting the work done, than actually helping their client, in a sense, okay? And another thing that they do is they teach you to seek permission and not assert your rights. Always say this: once you ask for permission, you are inherently giving away your rights. So the best kept secret in law is that you were never powerless, you were just uninformed. The only reason that you struggle, or the only reason you are not able to take action, is because you're uninformed. You just don't know the education. This is why the education is more important than someone telling you step by step how to do something, okay? Because if you know the law, then the steps kind of just come to you already. Yes, you know step by step, but after you learn the step by step, and I have plenty of videos that break down step by step processes for free on my YouTube channel. If you go and watch those videos, and let's just say you take those steps, what's going to happen is they're going to say something to you that's going to keep you from getting to step 2 or step 3. And when you don't know step 1, when you only do step 1, and you don't know what step 1, your actual rights for doing step 1, and you don't know what to expect and how to respond, that's when you feel powerless. So take the information serious rather than not, okay? So I want to talk about some powerful legal remedies hidden in plain sight, okay? Number 1, I have a full video on this, and I may remake the video for all the new subscribers, okay? Breaking it down a little bit more simpler and things in that nature. When we go to 15 U.S.C. 1635, it says it's the right of rescission as to certain transactions. So this specifically talks about mortgage transactions, okay? And technically you can use this for other types of transactions, but this works best for a mortgage transaction, okay? If you can argue, or the certain things that you can challenge in terms of rescission, okay? It wouldn't necessarily be you like rescinding a car, whatever the case may be, but you can challenge the validity of a contract and rescind a contract, okay? But this specifically talks about mortgages, right of rescission as to certain transactions. Now, most of you guys don't know that in a transaction, they must give you a notice, okay, saying that the obligor shall have the right to rescind the transaction until the midnight of the 3rd business day following the consummation of the transaction, okay? Or the delivery of the information and rescission forms required under this section together with the statement containing the material disclosures under the subchapter, okay? The creditor shall clearly and conspicuously disclose, in accordance with regulation with the Bureau, to an obligor in a transaction subject to the subsection the rights of the obligor under this subsection. The creditor shall also provide, in accordance with the regulations of the Bureau, appropriate forms for the obligor to exercise his right to rescind in any transaction subject to the subsection. So By law, you're supposed to get a letter, or you're supposed to be getting a document, a disclosure saying that you have a right to rescind a loan or cancel or revoke an agreement even after you sign, and how much time you have. Okay? If they don't give that to you, then you can rescind it. Then we can talk about UCC 3-305, which gives you the ability to challenge instruments for fraud or lack of consideration. Again, these are the remedies hidden in plain sight. Okay, yes, we can go to Uniform Commercial Code and it may seem confusing. Okay, Article 3 talks about negotiable instruments. Okay, and a lot of people will look at this and say, oh my God, this looks so confusing. This is a lot, but it's really easy once you understand exactly what each thing means. This one talks about negotiable instruments. This talks about when the issue of an instrument. This talks about unconditional promise or order. If you're hearing some of these key terms that I talk about, come to Article 3. You'll be able to learn a lot about negotiable instruments alone. Okay, but they're not telling you anything about negotiable instruments. They're only telling you that you're signing an agreement, and when you agree to something, you must adhere to that agreement. But they won't talk about how that agreement is a negotiable instrument. It's not an agreement. It's not an exchange. It's not a real contract. But also under this subsection, when you look at, it talks about negotiation and transfer. It talks about the enforcement of instruments. The enforcements of instruments is all under this subsection right here. Holder in due course, the person entitled to enforce the instrument, the value in consideration, overdue instruments, defenses and claims of recoupment, okay? Claims of an instrument, notice of breach of fiduciary duty, okay? Did you guys know that when you guys apply for something and you submit a promissory note, or you agree to a loan, or you fill out an application, they now have a fiduciary duty, okay? And you are the beneficiary. So they have a fiduciary duty to benefit the beneficiary, okay? They became a fiduciary, and as a fiduciary, they can go in and out of the trust or whatever the case may be, and they can essentially transfer funds into your account. But they don't even do that as the fiduciary. They just actually type in numbers. So they're not even really they're not even exercising their fiduciary duty. But I'm not here to talk about that. We'll just talk about the fact that when they don't do this, there is no value and consideration. And when there is no value and consideration, then you can defend against claims and recoupment. Okay? You can defend against instruments that have fraud or lack of consideration. Then we dive into 15 USC. Then we dive into the Truth in Lending Act. The Truth in Lending Act is pretty much the truth in lending. So it's everything in aspect of understanding your rights under lending. So when you think of truth in lending, just know that anything that is being lent to you requires full disclosure. Not only from the disclosure of, what you agreed on or that loan agreement, but it should disclose how the money was originated. You know what I mean? You have a right to ask these things under the Truth in Lending Act. Then we dive into the FDCPA, 15 USC 1692, okay? Under 15 USC 1692, and I'm showing you guys this whole section because all the details are here. Remember me talking about how everything is in the fine print? When you come here and you start to read these things, it really is, this is what they don't tell you, okay? They'll tell you that you owe a debt, but they won't, and they'll tell you that the Fair Debt Collection Practices Act, or whatever the case may be, or we're a licensed debt collector and this, that, and the third. They'll give you something and say, check this box if you want to dispute the debt and this, that, and the third, but they don't tell you where to come and actually see your rights for yourself, okay? Understand that this stuff is here for a reason, okay? They kind of have to put it there because if they didn't give you an opportunity to get out of something, then yes, it would be slavery, and slavery is illegal. It's unlawful. Forget illegal. Illegal is commercial. Unlawful is adhering to common law. Okay, remember those higher powers I'm talking about. So it'll break down the definitions. It'll break down acquisition of location information and how important that is if that's just given away. As far as third-party repossessors and things of that nature, this is a violation. It talks about how they should properly communicate with you as regards to a debt collection. It talks about the different forms of harassment and abuse, getting multiple calls and things of that nature at weird times of the day, late or early times of the day, or, when you send a cease and desist cease and desist letter, and for them to only send letters as regards to your dispute of the debt, and they decide to still send letters about the bill or try to collect after you tried to dispute the debt, that's considered harassment or abuse. They're abusing their power, whatever the case may be. False and misleading representation, making you think that they are somebody that they're not, making you think that information that they're giving you is the correct information when it's not. You know, even the aspect of them saying that whatever you're doing, especially when you're adhering to the law, is something that is fraudulent, that's false and misleading. Okay? Fair practices, the fact that you can validate debt, multiple debts, legal actions by debt collectors, furnishing deceptive forms that are deceptive or deceiving. The civil liability, they'll be under civil liability for violating any of these sections here. Okay? Then we talk about UCC 1-308. UCC 1-308. You know what I mean? Under UCC 1-308, it breaks down the performance or acceptance under reservation of rights. A party with explicit reservation of rights performs or promises performance or assents to performance in the manner demanded or offered by the other party, does not thereby prejudice the rights reserved. Such words, without prejudice, under protest, or the like, are sufficient. Okay, so long story short, if you agree to a contract and you put UCC 1-308 or you put under protest or without prejudice, it means that you don't agree to waive your rights. Okay, they'll put things in the contract and fine print that waives your rights, and you know, this is something that actually protects you against that. Look, if I didn't fully understand this contract, then I didn't waive my rights. Okay, if I didn't have the legal capacity, I didn't waive my rights. Okay, but there's so many things that I could talk about, and I may have to do a separate video about each and every aspect of the law. But I can break down 12 USC 412. Okay, the issuance of Federal Reserve notes. Okay, it talks about how FRNs are issued by Federal Reserve banks, which is the dollar. Okay, which is something that they borrow. It supports the idea that money is debt and issued without substance or backing unless redeemed. Okay, so this is a good use case for debt discharge and understanding fiat currency. Okay, because a lot of time we'll come out here and think that everything is BS. But when you look at this, it talks about how the Federal Reserve makes the money, or the fact that banks borrow from the Federal Reserve with no financial backing. So why do they force you to have financial backing? Okay, then we could talk about 12 USC 248, which breaks down the powers of the Federal Reserve. It defines what the Fed can't and can't do. It talks about, it shows the limits of their power and how to establish remedy. Okay, the beauty about looking at these and kind of gauging this, and I'm not going to go through it in its totality. I'm just bringing these up because I've seen people put it in the comment section. But when you look at these, it builds more confidence, okay, in understanding the remedies that you actually have as a consumer. Okay, we can also talk about UCC 347, advances to member banks on their notes, which pretty much breaks down and proves how banks create money through negotiable instruments, your promissory note, what they will call your loan agreement. And this is the use case for it: contract remedy and hidden value in signatures and instruments. You dig me? We can also go to 12 USC 503, okay, which talks about who is accountable in the banking structure. So essentially, the remedy via commercial liability or notice of fraud. If there's anything fraudulent, the directors or the banks are the ones that will be liable under this. Okay, so they cannot knowingly violate, okay, or permit any agents or officers of any member bank to violate any provision of the sections 375, so on and so forth. Okay, then we go to the aspect of bank fraud, 18 USC 1005. This covers making false entries or fraudulent loans. And essentially, if the bank can't produce an original note or commit fraud, this is something you can defend against. This is something you can rescind a loan about. These are the things that are put in place that says, hey, look, if this happens, there is a remedy that you can use against it. Okay, we can then go to 12 U.S.C. 1813, which defines deposits in the context of federal deposits, which refers to the unpaid balance of money or its equivalent held by a bank or savings institution. So long story short, a deposit is an unpaid balance. You feel me? And I could go on and on. I can go to 16 CFR 433 dot 1, which talks about your preservation of consumer claims and defenses, unfair and fair or deceptive acts or practices. This is another section that allows you and pretty much breaks down that you have the ability to challenge and defend against unfair and deceptive acts or practices when it comes to contracts. So there's so many angles that you can take. And again, I mean, I just throw these out there so you can throw it in your notes and you can go and take a look at these yourself when you get a chance. But here's how to start spotting the remedy for yourself. Okay? Because every legal weapon has a shield, but only if you know where to look. So I threw those out there so you guys know exactly where to look. So how to start spotting a remedy for yourself. Always ask, where is the out? Okay? Just know if there's a way in, there's a way out, like I stated before. Learn to read the definitions, exceptions, and references. Don't be afraid to read the definitions. When you look at the deposit and the fact that it says it's an unpaid balance, that's something you cannot just gloss over. Okay? One will not look at that definition and say, well, they said they deposited money into my account. But what if I told you that depositing money in your account is an unpaid balance? It's literally them saying that they owe you money. Okay? I know you guys know what unpaid balance is. That's what they say that you have, an unpaid balance. You understand me? Then we could talk about where to go. I'm on Cornell Law. You can go to Justia. You can go to the Uniform Commercial Code. You could just look these up on Google. Okay? You don't have to get it all. I'm not on DuckDuckGo. I'm not on the dark web. I'm not on anything like that. I'm on Google and I typed in Cornell Law, Justia, Uniform Commercial Code. I actually typed in the code itself and I know to go to Cornell Law. I know to go to Justia. I know to look for UCC. Okay? Focus on procedure over drama. If you learn the procedures, then it's not about, the emotional aspect. Get the procedure down. And when you got the procedure down, then you're going to be able to get remedy. Okay. Focus on how to proceed with things and don't focus on how to be emotional about it. Make drama about it. All right. This is not how you're going to win, by being dramatic. Okay, I talk to people all the time that tell me about a situation that they had where they're saying, well, I fell on hard times and this, that, and the third. And I get that. We fall on hard times, things of that nature. But I look at it with discernment. Okay, look, I understand you fall on hard times. We all do. But they don't really care about the hard times. You know what I mean? Like I said in previous videos, the court don't care to bring justice, even though they're the Department of Justice. They only care about the procedures and how to make money, okay? Because the court is also a bank as well, okay? Assume remedy exists and find it before reacting. So if you're in a situation to where your car gets repossessed, you're in a situation where you have a debt that you cannot pay, when you're in a situation where your credit is messed up or whatever the case may be, instead of going based off of what they say and saying, oh, I gotta wait 7 years, or damn, I gotta pay this collection, or damn, my car is gone, there's nothing I could do about it, you know what I mean? And I'm gonna scream at them and yell at them and get mad at them and this, that, and the third. Go look and see if they executed their procedures properly. Go look to see if they followed the Fair Debt Collection Practices Act. Go look and see if you challenge the contract or challenge the contract, giving them conditional acceptance. Go follow those procedures and figure out how to be able to communicate with them and shift the burden of proof onto them, so that yes, you took my car, but I already knew it was coming. I already knew that my car was going to get taken. I already knew that was going to happen. So up until that point, did I make sure I did my due diligence? So if they do take my car, I have something to fight against. Okay? It's not that I knew these things and I knew they wasn't supposed to do it, but if I didn't actually take action and set it up to the point to where, boom, if they decide to take my car, I have the evidence to challenge them. Okay, I sent my conditional acceptance. I sent my debt validation letter. I communicated with the debt collector prior. I didn't receive a notice. And this is something that is under the Fair Debt Collection Practices Act. These are things that you can do under UCC 9-210 is Acts for the Accounting. These are things that you can do under the Truth in Lending Act. And I've exercised my rights properly and I moved in good faith and they decided to ignore me and still repossess my vehicle. Then boom, it's not that yes, I can be upset about that, but boom, I already know I can win this because I've already taken the necessary precautions and steps prior. I already did the necessary procedures. You dig me? When you understand these things, then you really move with less fear and you move in power. Okay. So again, stop waiting for permission and start reading the law for your power. The reason why I bring this stuff up, the reason why I focus so much on the education, and I'm not just up here telling the person exactly this is how you discharge debt, is because everything that I talk about in the video, literally, if you watch the videos to its totality, I'm literally saying it to you. Okay, yes, I'm not pulling up every single form and say, hey, step 1, you send this letter. Step 2, you send this letter. Step 3, because every single case is different. Okay, you can send every single letter and they don't respond for the next 3 months. And instead of you challenging them on that, on their non-response, you'll just say, oh, well, maybe they just will leave me alone. No, you know what I mean? That doesn't work. When you know the law, then you know exactly, okay, this could come, but I know I'm going to be able to bite them in the ass for that. Okay, so now that we understand that the remedy is hidden in plain sight, and once you learn to read the law like a map, you'll stop being a victim of the system and start navigating it. See, I'm not for the victim mentality, okay? Because anything that happens to you is for you, okay? Your car is repossessed, or your house got foreclosed on, or you got late payments on your credit report because of you and your negligence, okay? Yes, they're not supposed to report it late. But do you know how to challenge them and challenge them for their unlawful reporting? Okay? Because if you don't know, then you're being negligent to the education. Okay? You're choosing to be ignorant. Okay? And again, ignorance is not bliss. Okay? Be willing to question everything. Be willing to challenge the company. Be willing to assert your rights when needed. Okay, and I say when needed with emphasis because a lot of times we want to just assert our rights and we don't really need to. Okay, we want to get free money and we want it to be easy by just sending a letter to them and hoping they'll give us money. And when they don't give it to us, instead of us going through the full process or learning the full process or understanding how the money will be put into your account, we'll just be upset and say, well, I did this process, it didn't work. Okay, so let's move with that power. You feel me? Yes, this is a slightly longer video. Yes, I'm a little bit more calm, cool, collected, whatever the case may be, because this is an educational video, and I know you guys are taking notes. I know you guys are putting action towards it. And, I'm not, I'm here to really, just empower you guys to just read the law and take action. You dig me? Take action on whatever it is that you need to take action on. If it's your goals, if it's your if it's your goals, if it's on your debts, if it's on your credit report, whatever the case may be, just take action. Whether it's I need to learn some extra information, whether it is I need to apply what I just learned, whatever it is, just take action. Because when you take action, you now take control of your life. You now take charge of your life. And that's my whole message behind everything that I talk about, is for you guys to start taking charge. You dig me? Take charge of your life and don't let anybody else have authority over it. Dig me? So boom, if you want to learn more about this, down below is the Complete Debt Guide. You can get the Complete Debt Guide for $47 right now, and you can be able to get the templates. You'll be able to get things like the remedy starter guide. You'll be able to get things like the credit reclamation kit and things in that nature, so that you guys can know how to reclaim your status on the aspect of communication and administrative processes. You'll learn about conditional acceptance and how to be able to how to send conditional offers to a company, the exact letters and things that I'll give you all the letters. I'll give you all the steps that I personally put together. but it's still up to you to make sure you do your due diligence and learn everything. Okay, don't take everything for face value. Make sure you do the due diligence. Then on the aspect of, if you want to work with me one-on-one, down below is a link below. Go ahead and click that link if you want to apply to work with me. Now, it is an application, so we don't take everybody and we don't call everybody. Okay, depending on how you respond will determine whether we're going to give you a call. Okay, number 3, if you want to follow me on Instagram, it's down below as well. Follow me at biz.nick on Instagram. If you follow me on biz.nick on Instagram, you'll get updates on my YouTube videos. I do post every day, Monday through Friday at 8:30 p.m. And lastly, comment below if you ever felt stuck in a system you didn't understand. Remember to hit the like, subscribe, hit the bell, because once you see remedy, you'll never see law the same again. I love you guys. Make sure to comment the word discharge if you got all the way to the end, and I'll see you next time.